Lysander Spooner's No Treason, the Constitution of No Authority. Part 4. The Constitution not only binds nobody now, but it never did bind anybody. It never bound anybody because it was never agreed to by anybody in such a manner as to make it, on general principles of law and reason, binding upon him. It is a general principle of law and reason that a written instrument binds no one until he has signed it. This principle is so inflexible a one that even though a man is unable to write his name, he must still make his mark before he is bound by a written contract. This custom was established ages ago, when few men could write their names, when a clerk, that is, a man who could write, was so rare and valuable a person that even if he were guilty of high crimes, he was entitled to pardon, on the ground that the public could not afford to lose his services. Even at that time, a written contract must be signed, and men who could not write either made their mark or signed their contracts by stamping their seals upon wax affixed to the parchment on which their contracts were written. Hence the custom of affixing seals that has continued to this time. The law holds, and reason declares, that if a written instrument is not signed, the presumption must be that the party to be bound by it did not choose to sign it, or to bind himself by it. And law and reason both give him until the last moment in which to decide whether he will sign it or not. Neither law nor reason requires or expects a man to agree to an instrument until it is written. For until it is written, he cannot know its precise legal meaning. And when it is written, and he has had the opportunity to satisfy himself of the precise legal meaning, he is then expected to decide, and not before, whether he will agree to it or not. And if he do not then sign it, his reason is supposed to be that he does not choose to enter into such a contract. The fact that the instrument was written for him to sign, or with the hope that he would sign it, goes for nothing. Where would the end of fraud in litigation if one party could bring into court a written instrument without any signature and claim to have it enforced upon the ground that it was written for another man to sign, that this other man had promised to sign it, that he ought to have signed it, that he had the opportunity to sign it, if he would, but that he had refused or neglected to do so? Yet, that is the most that could ever be said of the Constitution. The very men who drafted it never signed it in any way to bind themselves by it as a contract, and not one of them probably ever would have signed it in any way to bind himself by it as a contract. Yet the very judges who profess to derive all their authority from the Constitution, from an instrument that nobody ever signed, would spurn any other instrument not signed that should be brought before them for adjudication. Moreover, a written instrument must, in law and reason, not only be signed, but must also be delivered to the party or to someone for him. The signing is of no effect unless the instrument be also delivered. And a party is at perfect liberty to refuse to deliver a written instrument after he has signed it. He is as free to refuse to deliver it as he is to refuse to sign it. The Constitution was not only never signed by anybody, but it was never delivered by anybody or to anybody's agent or attorney. It can therefore be of no more validity as a contract than any other instrument that was never signed or delivered.